Hello guys, good day. Welcome back sa ating channel and welcome back for another lecture in the Division Criminal Jurisprudence. No? So we're uploading a review lecture, no, for those who will be taking their licensure examination for criminologists this June 2022. Okay? So without further ado guys, kasi medyo mahaba-habang usapan tong tatalakayin natin ngayon, no? But to give you a preview on the topic for today, we're going to talk about hearsay evidence or the exemption, specifically the exemption to the so-called hearsay rule. Okay? So ayan guys, let us immediately jump into our discussion. As again, no, bali ang discuss natin, no, in order for us to discuss the matter, we need to formulate a question that will facilitate us, that will introduce us to the topic that we will be discussing for today. So, ayan guys, now without further ado, let me read the questions to you. Question to you. Okay, so we have here the question. No, Marites went to file a case of abortion against her neighbor. Her primary evidence was the testimony of one of her kumare that her neighbor went to Aling Pasing to have an abortion performed. Question there is, will the complaint of Maritas prosper using the nature of the testimony mentioned above? Okay, so we have here four choices, no? But before we discuss, no, what is the answer for this question, let us have an overview first, or a general understanding on what's the concept of a hearsay, no? Kasi basically, the topic that we wanted to tackle today is all about hearsay, no? Patungkol sa hearsay. So ano nga ba yung tinatawag nating hearsay? Anyway, our reference for the discussion for today will be the rules of court, no, that we have here in our country. So we know for a fact that one qualification for a witness is that all the thing that he should, or he is, no, he is testifying into should all be perceived by his or her personal knowledge. So ibig sabihin, ang pinaka-rule natin ng korte natin dito sa Pilipinas is that you are only allowed to testify doon sa mga pangyayari na ikaw mismo ang personal na nakasaksi. That's the concept of that's the major requirement, no, for a testimony to be accepted as an evidence. Now, lahat ng bagay, no, na tinetestify mo, na sinasabi mo, na hindi naman ikaw mismo yung nakasaksi, will all be considered as hearsay. No? And of course, generally, no, our court, no, the rules of court does not admit hearsay as an evidence. Hindi po nila tinatanggap ang hearsay. Yung mga, kumbaga, ang tawag natin dyan is chismis, no, bilang ebidensya sa korte, no, to indict somebody, no. Ngayon, despite the fact that we have a general rule with regards on how we treat hearsay as an evidence, no, the law has still provided exemption to the hearsay rule. So, sabi natin ay hindi maaari or hindi tinatanggap ng korte yung mga tinatawag nating hearsay or yung mga testimony that are not, no, founded on the concept of personal knowledge. But it also provided exemption to that rule. Meron din tayong mga exemption at yun yung mga tatalakayin natin ngayon. Ano? Sabi ko nga medyo mahaba-haba to kasi madami-dami naman yung exemption. No? Now, let's jump into the different exemption to the hearsay rule. No? So if we're going to look into the section 37, no, una sa exemption ng hearsay is the so-called dying declaration. So if the testimony is founded, no, on the concept of dying declaration, kahit hearsay siya guys, no, it will still be accepted as an evidence by the court. Ano ba yung nature ng dying declaration? You know, dying declaration usually sometimes, syempre may requirement yan. No? Una, it should be related to the death, to the cause of death of the person who is about to die. No? So dapat ang testimony na ibibigay niya, ang testimony na ibibigay ng taong yan ay patungkol doon sa circumstances kung bakit siya or kung sino ang pumatay sa kanya. No? So let's say for example, you are a police officer. No? Police officer ka, rumisponde ka sa isang insidente. No? Inabutan mo yung isang tao doon, no? Na siya ay nasa bingit na ng kamatayan. So mamamatay na siya. Ngayon, you ask, no? Ano yung nangyari sa kanya at sino yung gumawa nun sa kanya. Okay? So, halimbawa, nasabi niya na si ganito, si kumpare ko na si Juan ang bumaril sa akin. Okay? Nasabi ng biktima yun sa'yo. No? Bago siya malagutan ng hininga. Ngayon, no? You, as the recipient of the dying declaration, ikaw na nakarinig doon sa testimony ng biktima, could testify in court, no? About the identity of the person who allegedly killed or caused the death of the victim, no? Ikaw dahil ikaw yung nakarinig nung sinabi niya na si kumpare ko na Juan yung bumaril sa akin, ikaw yung nakarinig, namatay naman na siya, you should be the primary witness. But then namatay na nga siya and nabanggit niya, bago siya namatay, nabanggit niya sa'yo kung sinong gumawa nun sa kanya. Ikaw bilang recipient, ikaw bilang police officer na nakarinig doon sa dying declaration niya, can testify to the court. Siyempre, yung tatanungin dyan, no? Pag halimbawa, nandun ka na sa korte, at sinabi mo na si Mr. Juan na nakumpare ng biktima ang pumatay sa kanya, now would be asked, nakita mo ba? Diba? Nakita mo ba? That's the question that you should answer. But of course, wala kang personal knowledge. Hindi mo nakita na talagang si Mr. Juan ang bumaril sa kanya. But then, remember that the testimony that you are giving is a part of dying declaration. No? Pasok siya doon sa konsepto ng dying declaration. So even if you as a police officer don't have personal knowledge as to the circumstances on who, no, as to the identity of the person who caused the death of the victim, no, basta you can justify that there is a dying declaration that is based on the concept of dying declaration, then that will be accepted as evidence, no, even if you don't have personal knowledge onto that matter. Okay? That's number 1. Under Section 37, dying declaration. Section 38, guys, meron din tayong tinatawag na declaration against interest. Now, still an exemption to the hearsay rule. What about declaration against interest? Okay? So again, you are a police officer. You went to the crime scene kasi may tawag na may hold up ang nagaganap. Nagkaroon ng putukan, no? Between the police officer, no? Kayo na rumisponde doon sa bangko na kung saan lumaban kumbaga itong mga suspect. So, majority of them escape, no? Majority of the group escape, pero meron kayong isang nabaril, napuruhan, no? Napuruhan nyo halimbawa yung isang kasama nila, no? Then, you went to him, pumunta ka sa kanya, then sabi mo, sino yung mga kasama mo? Something like that, no? Sino yung mga kasama mong nang hold up, no? You ask that question to him. And it just so happened na syempre mamamatay na rin siya. It would be unfair to him, di ba? Parang mag-i-squill na lang siya, na parang ilalaglag niya na lang yung mga kasabwat niya doon sa crime na kinumit nila kasi mamamatay na siya. So if he did that, halimbawa, nag-squill nga siya, no? Sinabi niya sa inyo, ang kasama kong nang hold up, si Pedro, si Juan, si Mario. Then he died. Namatay siya. So, we can consider that as a declaration against interest. No? Kasi, why would he, no, a person who is about to die, would mention some names? No? See, that is against them. That is, kumbaga, self-incrimination. Kasi he is admitting that he is one of those pearls of the group na nang hold up doon sa bangko. Plus, he even made mention or he even dropped some names. Okay? Now, even if you don't have personal knowledge, no, you as a police officer, wala ka namang personal knowledge kung sino yung regarding the identity of those, no, yung mga kasama ni Juan. Kasama yung nabaril nyo, yung namatay, no? Wala kang personal knowledge as to that. Only you are relying on the testimony that was given to you by one of the suspect who is about to die, no? Kumbaga is, ayun, bago siya namatay, binanggit niya kung sino-sino yung mga kasamahan niya. No? That is a hearsay on your part if you will be testifying in court, di ba? Kasi the judge or the lawyer of the other party would definitely ask, bakit have you able na-identify mo ba yung mga kasama ng taong ito na nagnakaw, no? Ano yung evidence na may papakita mo that will prove that indeed these persons you are accusing are actually a part or had participated in that robbery, no? So again, it appears that here you don't have personal knowledge as to their identity. Now, the only basis you are relying to is of course the testimony of that person, yung isang suspect who is about to die, where he declared that etong mga taong ito yung mga kasabwat niya, which is supposedly against them, but still you can rely on to that. That is a hearsay, but of course that is accepted as one of the exemption of the hearsay rule. Okay? Section 39, act or declaration about pedigree. So we're talking about relationship, mostly on relationship. No? So for example, a person who is about either he doesn't want to testify, ayaw niya mag-testify, or hindi naman kaya is mamamatay na siya, talk about the relationship of one person to other. Let's say for example, relationship matters. May inamin siya, halimbawa na si Pedro ay anak niya talaga si Juan. Okay? So, let's say for example, this is for halimbawa sa mana, no, ganyan naman mga civil cases, no. Mana, no, sa mga properties, inheritance, mga ganun ba. So, let's say for example, bago mamatay yung isang tao na yan, then he testified that of course this person was actually the son of that person, diba? He's testifying on the relationship of two person, no, that he, no, he should be, no, yun yung ano natin dito, yun yung requirement natin, that a person who would testify about the pedigree, about the relationship of one person to another, must be a part of that family. Dapat miyembro siya ng pamilya, hindi yung kapitbahay ka lang or whatsoever. You should be a part of the family. Whenever you are declaring or whenever you are testifying about the pedigree of one person. So, let's say for example, now that before he died, he made mention that he declared that these two persons are related with each other. No, he is the father and this is the son. No, before he died. So, ikaw as a recipient again of that declaration can testify as to the relationship of that person involved therein. No? So, yun nga. Let's say for example, mana ang usapan, inheritance. No? Mr. Pedro is denying that anak niya si Juan. No? So, gusto ni Juan na ikilalanin siya ng ama niya para nang sa ganun ay magkaroon din siya ng part doon sa mamanahin niya. So, yung lolo nila na malapit ng mamatay testified, no, in favor of Juan. Sabi niya, totoo na anak ni Pedro si Juan. Then he died. So let's say for example, you are the lawyer, no? You are the police officer, or you are the person who heard that declaration. Then you, no, even if you don't have personal knowledge as to the relationship of Pedro and Juan, can testify in court proving the relationship of the two person involved based on the declaration or based on the declaration about the pedigree as an exemption to the hearsay rule. Okay? So I do hope clear yun. No? Section 40, family reputation or tradition regarding pedigree. So this is somewhat related, but we're talking about reputation and tradition, no, of a certain family. You know, when we are talking about reputation, it's hard really to have one witness that will entirely prove the reputation, 'di ba? Kasi pag sinabi nating reputation, it is a collective opinion of many person. No? Hindi ito opinion lang ng isang tao. No? Hindi pwedeng dahil sabi ni Pedro, maganda ang reputation niya bilang isang family, then all things is settled already. It's not like that. Hindi ganun 'yun. Okay? So, let's jump into an example that we can illustrate section 14. Okay, so for example, I'm a part of a political clan. No? If I'm a part of political clan, no? And then the traditions, the reputation of our family clan is being put into question. Let's say for example, may kasong sinasampa sa amin sa family namin, no? Regarding corruption, no? Regarding malpractice, regarding mga political issues, no? So, let's say for example, ako hindi ko na kaya yung nangyayari. Hindi ko na kaya yung kalakaran ng pamilya na ito. No. So, I testified against them. Sabi ko, okay, these are all the trades that our family are engaging into, no? Halimbawa, we are supporting the rebel group. Yan. We are selling drugs. We are involved in many corruption. We are involved in many massacres and something like that, no? My testimony as to the reputation of the entire family could be accepted, no, as an evidence, no, in exemption to the hearsay rule. No? So, for example, I didn't personally witness the member of my family doing all these things. No? Hindi ko siya na-witness personally na si lolo ko na-involve sa pagpatay, yung parents ko are involved in corruption, things like that. Even if I didn't personally witness that, but being a part of that family, I should know. I should know that. Na talagang alam ko dapat yan. Kasi, this is a family, no? Wala kang maitatago sa kapamilya mo. So, alam mo kung ano yung kalakaran dyan sa loob, alam mo kung ano yung ginagawa ng mga members of the family ninyo. Then me, even if I haven't personally witnessed them committing all these things, I don't have like video, writings, or any other sort of physical evidences. My testimony could still be accepted as an evidence, no, against this family, no? Even if I didn't personally witness them, I will be exempted to the hearsay rule, no, under section 40, no, under section 40. Now, for common reputation naman, kanina we're talking about family reputation. Ngayon, common reputation, like for example, one person, we're trying to establish the reputation of one person. So again, the concept of reputation, sabi ko nga, this is a collective opinion of those people who knows you. No? Ang reputation is established not only by one person, but those majority of the people that is living beside you, that had witness, that had personal knowledge as to how you behave as a member of the society in that community. Okay? Ngayon, if you are trying to prove a reputation of one person, di ba? It is really not ideal to bring all these people, no? Let's say for example, ang kapitbahay niya dyan is about 50, no? Just to establish the reputation of that person, are you going to bring all these people, no? Dalhin mo ba lahat ng mga taong to, yung mga kapitbahay niya, just to prove the reputation? No, that's not practical. So, what you could do is to get the collective opinion of this group, no? And interpret that, what does it means? Does this person have a good reputation, or does he don't? No? Wala ba siyang magandang reputation? Okay. So, again, no? If, for example, I concluded that based on the interviews I conducted, based on the research I conducted, this person is in good reputation. Maganda yung reputation niya sa community niya. Who will testify? As to the reputation? Diba? Ako. Kasi ako yung nag-research, ako yung nangolekta ng data regarding, ako yung nagkilatis kung ano ngayon yung reputation niya based on what the community perceive him to be. No? So, ako na yung magta-testify in court as to the reputation. So, I could be questioned. Pwede akong tanongin dyan, bakit? Nakita mo ba siya? Na lumaki? Nakilala mo ba siya? No? Personally? No? Nasubaybayan mo ba yung buhay niya? That will be the question that will be thrown to me. Yan yung mga tatanungin nila sa akin no? To determine whether I have a personal knowledge or not. But of course, syempre, I don't have personal knowledge. But, again, we're talking about reputation. No? Since we're talking about reputation here, no? So, there is an exemption on the hearsay rule as to the establishment of reputation. No? So, yan. Exempted yan. Kasi we're talking about reputation. Kahit hindi ko personally nasaksihan yung pamumuhay, yung uri ng pamumuhay ng isang taong to, but since we're talking about reputation, then I should be exempted on the hearsay rule. Okay? Next, Section 42. Part of the res gestae na tinatawag. What's part of the res gestae? Part of the res gestae is a, like for instance, no? There is merong kayong meron kayong informant na nagsabi, tumawag sa inyo, sir, halimbawa, you're police station kayo, no? Sir, may susugod dyan sa inyo, sa istasyon ninyo, no? Bobombahin kayo, susundugin yung istasyon ninyo. Yung mga yon ay sina Pedro, si Juan at si Mario. No? Yung grupo ni Pedro, Juan at Mario, susugurin kayo dyan, bobombahin kayo dyan sa istasyon nyo na yan. Okay? So that's the tip, no? Yan yung message na na-receive mo. Okay? So, if the caller did not identify himself, no, hindi niya naman dineklara kung sino siya kasi nga 'di ba? For safety reason and so on. Now, if it happens na nagkatotoo nga, no, after niya tumawag, an hour later or a day after, no, sinugod nga yung istasyon ninyo, no, binomba kayo and so on. Now, parang maalala mo ngayon na merong nagsabi na ang gagawa nito ay si Juan, si Pedro at si Mario, no? Ngayon, if you're going to file a case against these people, this alleged perpetrator of the crime, di ba? Pagsasampa ka ng kaso, sino yung ididiin mo? Based on the information that you received, it was Mario, Juan, and Pedro, no? So you would be asked by the court, no, whether do you have personal knowledge? Nakita mo ba, na-identify mo ba na si Mario, si Pedro, at si Juan yung pumunta doon sa istasyon nyo, nagbomba sa inyo, nagsunog sa inyong istasyon and so on. So, you will appear to have no personal knowledge about it, diba? Siyempre, ang magiging lagay nun is that hindi ko sila nakita, no? But then, we must consider, no, the fact that merong nag-tip sa inyo na merong susugod doon at sila, Mario, Pedro, at Juan, yung mga yon. At nagkatotoo nga. Ngayon, the justification, no, for your statement or testimony as a police officer who received that information could be Section 42 of the Rules of Court, now, which is the part of res gestae. You could use the information that was given to you prior to the commission of the crime, no, as part of the res gestae. No? Yung part of res gestae na yan could be, like for example, the information was given to you before the crime transpired, or during the crime, during the commission of the crime, or after, no, after na-commit yung crime, may tumawag sa inyo, nagsasabi na si ganito yung sumunog, yung nambomba sa inyo, things like that, no? You as a police officer could testify in court, no, using the justification of part of res gestae to make your statement admissible, despite you having no personal knowledge about the incident. Okay? Section 40, entries in the course of business. Okay? I'll give you an example for this, no? So, let's say for example, I went to your company. Halimbawa, yung company nyo is car rental. No? Paupahan ng mga sasakyan. So, nagrent ako ng kotse. No? Finilapan ko yung information sheet. No? Ikaw yung nandyan. No? Ikaw yung, kumbaga, duty. No? Duty officer of the day. Ikaw yung nag-receive ng ikaw yung nag-facilitate ng transaction, ikaw yung nag-receive ng application ko to rent a car, no? Ikaw yung nakakaalam kung sino ako na nagrenta ng car, saka yung ko lahat pinakita yung mga identification cards ko and so on. No? Then after that, no, I was supposed to return the vehicle today. Hindi ko binalik. Day after, wala pa rin. Then, hanggang sa medyo tumagal, no, then the company filed carnapping against me. No? Sinampahan na ako ng carnapping, hindi ko binalik yung nirentan kong sasakyan. Ngayon, let's say for example, pumunta na tayo sa korte. No? Pumunta na tayo sa korte. Okay? So, I have my information, di ba? Andiyan yung information ko, pangalan ko, address ko, no? Pagkakakilanlan ko, nandiyan lahat. So, you identified me, filed the case against me, nagsampa kayo ng kaso. Then, what if yung employee, no, na kausap ko, no, nakausap ko nung nagrenta ako ng kotse, for example, wala na, no? Let's say for example, nag-resign, di kaya may nangyari ng masama sa kanya, kung baga, I could have planned to para i-dispatch ako na siya para wala na akong testigo, wala nang testigo, parang gano'n. Yun yung thinking ko, no? So wala na yung kausap ko dati, wala na yung empleyado na yun. Ngayon, can they still pursue with the case? No? Pwede pa rin ba silang mag-pursue with the case? No? The answer is yes. Why? Kasi my identity is properly established during the business transaction. No? Ngayon, anybody from that company could testify against me. Pwedeng kahit sino sa kanila. It could be the manager, it could be yung pumalit sa kanya na employee, things like that. No? If the court will question these witnesses, di ba, tanongin nila, halimbawa, si manager ang nag-represent sa company. Sabi niya, si Mr. JB, no, nag-rent ng car sa amin ng ganitong araw, ganitong date, no, and so on, so on. So, my lawyer could ask, personally ba nakita mo itong taong ito na pumunta sa opisina ninyo, kumuha ng sasakyan, nagrenta ng sasakyan, nag-fill up ng ganito, and so on, and so on. Okay? So, that is somewhat like a question to identify whether that person who represents the company have personal knowledge. Diba? Parang tinetest nila kung may personal knowledge. Kasi diba, ang rule natin, pag wala kang personal knowledge, you cannot testify. However, this is a part of the so-called exemption to the Hearsay rule. Part ito ng exemption to the Hearsay rule, section 43. No? That entries in the course of business, no, is already a valid evidence. Despite, no, kahit sino, no, ang kahit sinong representative ang mag-represent sa company involved, no, pwede silang mag-testify basing on the entries that are basing on the entries on the business records that they have. Okay? So it's not necessarily na kailangan ang mag-testify, no, sa isang business transaction yung mismong nakatransact mo, no? As long as the entries, no, as long as the controversies are about the entries on the record, then anybody from that company could represent or could represent the company into the witness stand. Okay? Now, that is in relation also to section 44, entries in the official record. Okay? So, kanina, it's about business. Ngayon naman, official record. Let's say, for example, I'm the barangay captain. Barangay captain naman ako ngayon. No? May pumunta sa akin, nag-complain to sa ganito, no? Ay binugbog sa ganyan, no? Parang nagpa-blatter sa barangay. Okay? Ngayon, let's say, for example, it went to the court. No? Pumunta, umakyat siya sa korte. So, I was called to testify. No, I was called to testify whether or not si Mr. Pedro at si Mr. Juan ay pumunta doon sa barangay at nagsampa ng kaso na ganito ganyan, no, na may pambubugbog na nangyari, things like that. Okay? So let's say for example, I'm not available. Na wala ako, kumbaga for whatever reason I'm not available to testify. Okay? Now, anybody from our office can be the representative. No? Can be the representative. He can represent me. No? For example, Barangay Kagawad, siya yung available. Punta sa Barangay Kagawad doon sa court, siya yung nag-testify, siya yung tumayo sa witness stand. Now, tatanungin si Barangay Kagawad, Barangay Kagawad, nandun ka ba nung pumunta si Mr. Juan at si Mr. Pedro, nagsampa ng ganitong kaso, nagpa-blatter? He could say, no, wala ako doon, hindi ako naka-duty. Okay? So that will be put into question whether that Barangay Kagawad has personal knowledge on the issue. No? That is a hearsay. However, it is exempted since Barangay Kagawad will only testify based on the entries made in the official record. Okay? So lahat ng official record on that barangay, no, anyone from that office could represent, no, could represent the office to the witnesses stand, since they are talking about official entries on the official record. So mga entries yan. So yan, since that is already put into record, so anyone from that office, pwedeng si Barangay Kagawad, pwedeng si Barangay Captain, no, and any other person delegated therein could go to the witness stand and testify on this matter sa mga issues na to. Okay? So, that is entry sa official record. Di ba kanina, business, ngayon official records. That applies also sa mga logbook, police logbook, things like that. Guards, na mga ganun. Okay? Section 45, commercial list and the like. Okay? So, mga commercial list naman, for example, di ba, we have, I remember the issues on melanin before. Okay? So, there was an allegation that some, yung mga nagproproduce ng mga asukal, na nagproproduce ng mga, how do you call this? Powdered milk, no, ay hinahaluan nila ng melanin yung kanilang product. Okay? So, because of that, let's say for example, may nagsampa ng kaso na nagkaroon ng health problem yung kanyang anak or nagkaroon siya ng health problem because of this product, no? Halimbawa, bumili siya ng gatas na ganito. Ininom niya, kinonsume niya, nagkaroon siya ng sakit, nagkaroon siya ng nakasama sa kalusugan niya, nagsampa siya ng kaso against that company, no? Accusing them that they put some, substance that is dangerous to the health of the consumer. So let's say for example, melanin. Okay? Ngayon, in the court, no, pwedeng ang maging issue dito is that halimbawa, I accuse them that they put some melanin on this product. That's why yun yung nag-cause ng health deterioration ko. So the court could philosophize this, no, or the lawyer of the opposite camp could philosophize this. Bakit nakita mo ba sila personally na hinahaluan nila ng melanin yung kanilang product? Diba? Parang ganun yung maging tanong. To point out that you don't have personal knowledge. But then again, the section 45 of the rules of court, specifically on the exemption to the hearsay rule, mentioned that commercial lists and the like is an exemption. No? Saan ba nakalagay yan? Let's say for example, nandun naman sa product description that this product contains melanin, or nandun sa kanyang mga ingredients may contain siya melanin. That is enough already to prove that indeed that product contains some unhealthy substances or poisonous substances. Okay? You don't need to prove that you personally witnessed this company mixing this substance to their product, no? Kasi meron na on record, no? Meron doon sa kanilang product description, meron sa kanilang ingredients and the like. Okay? Now, section 46, learned treatise naman tayo. Okay. So for example, I'm a police officer, no? I'm assigned in the checkpoint. Nasa checkpoint ako. Then meron akong pinarang driver. Pinara ko siya. And I kinda suspect that this person has or is under the influence of liquor. No? So I requested him to move out from the vehicle. And sa akin, sir, labas ka muna. No? And then, di ba meron tayong sobriety test na tinatawag? The sobriety test, no? To test whether the person is under the influence of liquor or not. Okay? So lumabas siya, he complied. No? Then sabi ko, sir, could you perform this? Diba yung sobriety test, like walking, standing on one leg, things like that. Diba? Pina-perform ko yun sa kanya and he failed. No? Hindi niya nagawa ng tama. So, I supported now my suspicion that he is under the influence of liquor. No? So, I arrested that person, no? And then the case went to court. Now, I could be asked as the arresting officer, no? Do you have personal knowledge that this person really had drink alcohol? Nakita mo ba siyang uminom? Di ba? Parang ganun. No? To test whether you have a personal knowledge. And I could say no. No? Hindi ko naman siya nakitang uminom ng alak and so on. So, di ba? Parang mako-question yung integrity ko. Bakit mo siya hinuli? Hindi mo naman pala siya personally nakita na uminom ng alak. Things like that. But then, on the exemption of hearsay rule, even if I didn't personally witness that person drinking alcohol, but based on the common practice as to this profession, yun yung sobriety test na tinatawag ko. The sobriety test is a treaty. It's a practice that is already well established. It's based on scientific study that you can identify whether a person had consumed liquor, basing on by testing him to do the following. So, established na to, no? Established na to. So, that is my justification, no? That based on learned treatise, no? if a person failed to do this task, no, then he will be presumed that he is under the influence of liquor. No? So that is an exemption to hearsay. No? That is an exemption to the hearsay rule that we have. I didn't personally witness him drinking alcohol, but based on common practices on identifying whether a person had consumed liquor or not, he failed. Therefore, the logical assumption is that he is under the influence of liquor. Okay? Kumbaga, I am becoming an expert witness now. No? Parang kumbaga, I'm acting as an expert witness based on these things. Okay? Lastly, Section 47. Section 47 talks about testimony or deposition of a former proceeding. You know the Maguindanao case, di ba? Parang the Maguindanao massacre. Lagi nating naririnig na sa ganito, no, isang witness sa Maguindanao massacre, natagpo ang patay. Di ba? Parang unti-unti na silang nauubos. However, if these individuals had already made their testimony, kumbaga tumayo na sila sa witness stand, na cross-examine na sila, nasabi na nila yung testimony nila doon sa court, no? Even if what happens to them, no? Let's say for example, hindi na sila bumalik, hindi na sila makontak, no? May nangyari ng masama sa kanila, their testimonies are already accepted as an evidence despite them being either missing already or have gone into places already. So, testimony or deposition at the former proceeding, no, that renders it admissible already. No? Even if it was, let's say for example, hindi nila na cross-examine, but they were given a time to cross-examine the witness, but they did not perform cross-examination. It will already be considered as an acceptable evidence. Na exempted na siya doon sa tinatawag nating hearsay. Okay? Now, we go back to the question. No? Dito, we can say that the testimony that in question, the testimony in question here is an example of a hearsay. It is a hearsay. So we have here the choices. Yes, the complaint is supported with testimony. It is supported with testimony, but there's a question with regards to the acceptability of the testimony given. So it's not letter A. Letter B, yes, the testimony is sufficient evidence. As I've stated, it's a hearsay, so it's not sufficient. It's not sufficient. No, the evidence is a hearsay. Okay? So, we can kind of think that letter C is already the answer. D, no, the crime is not punishable. Of course, the crime is punishable. No? So, if we're talking about abortion, that's punishable. Clearly, no, the answer here is no. No? The evidence that is being presented is a hearsay. Kung titignan natin whether or not pasok siya doon sa mga exemption na tinatawag natin, na diniscuss natin kanina, it doesn't mention any. No? Hindi siya kasali doon sa mga exempted for the hearsay rule. Therefore, it is inadmissible. So the answer for this question is C. No, the evidence is hearsay. Okay? So I do hope guys you were able to learn something from this lecture. If you have questions with regards to this, feel free to comment on the comment section. Yan guys, if you want more of these lectures, I invite you to like our videos, bilang pagsuporta. You may share also our videos bilang pagsuporta. And you may subscribe also para updated kayo sa mga i-upload pa nating videos. Remember that we are doing it daily, until June 2022. So, that's it guys. I hope I was able to impart some knowledge with regards to the topic that we discussed. That's it for today. See you on the next lecture. Bye-bye.